So, ladies and gentlemen, it's time to really begin our summer 2025 session with the opening lecture of Mr. Paul Reichler. So, Mr. Paul Reichler is a practitioner of public international for more than 40 years, representing states in disputes with other states before international courts and arbitral tribunals. He participated in 20 cases before the ICJ, including 16 contentious cases and 4 advisory proceedings, with more than 40 oral arguments before the court. He knows how to speak. Among the most significant ICJ cases, everybody knows the famous Nicaragua versus United States case. He was, I think, lead counsel for Nicaragua. Argentina versus Uruguay, counsel for Uruguay. Legality of the United Kingdom's separation of the Chagos Archipelago from Mauritius, counsel for Mauritius. Legality of Israel's prolonged occupation, settlement and annexation of the occupied Palestinian territory, counsel for Palestine. The most significant non-ICJ cases include Philippines versus China arbitration, with counsel for the Philippines, and 2 e-close cases, Bangladesh versus Myanmar, counsel for Bangladesh, and Mauritius versus Maldives, counsel for Mauritius. He also represented states in investment arbitrations, most notably Uruguay in the case brought against it by Philip Morris International, which challenged Uruguay's tobacco control measures. He is member of the 11 King's Bench Work Chambers in London since 2023, and previously was a partner in 3 important US law firms. I mentioned last but not least, he is a graduate of Harvard Law School, and sometimes I have some nice thoughts for poor Harvard nowadays. Thanks very much, Paul, for being here. It's our honor to leave you the floor.
Thank you for those generous words. Being here today is a great honor for me. It's one that I did not expect, and I don't claim to deserve, but I'm very glad and grateful to accept it, and I thank Secretary General Touvenant and the members of the Curatorium for bestowing it on me. I want to assure you that I am here in The Hague entirely voluntarily. I have not been deported by the Trump administration, at least not yet. I've come a long way since March 1984, when I first arrived at the doors of the Peace Palace with my wife, Tricia, my lifelong partner, comrade, and co-conspirator. We weren't allowed in back then because we were told we had no business with the court. Knowing that Nicaragua v. United States would be filed early the next month, Tricia said, "No worries, they'll have to let you in the next time you come." And of course they did. And they've been gracious enough to let me in ever since, for more than 20 cases and over 50 oral pleadings. To say that my appearances before the court have been the highlights of my professional career would be a colossal understatement. My first argument in the Nicaragua case was also the first time I ever wore a morning suit, which is the traditional and formal attire in the ICJ for counsel from the United States. My suit was rented. I reached a professional milestone, for me at least, years later, when I began to appear frequently enough in the court to justify buying one. And I'm pleased to say it still fits. Despite the number of cases, the number of arguments, I have never lost the sense of exhilaration that I feel every time I stand up to address the court. I can feel my heart pounding and even see my left lapel over my heart rising and falling with every beat. After 40 years, this has not changed. Why is this so? Why does it happen every time I'm in the ICJ, but nowhere else? I've been counsel in dozens of cases before other international courts, interstate arbitral tribunals, and investor-state panels, often in cases that are significant and well-known, including the South China Sea arbitration, where I proudly represented the Philippines. As exciting as those cases have been, the sense of awe that I experience only comes at the ICJ. Why? My answer to this question tells you some of the things that I've learned about litigating before the court over the 4 decades since the Nicaragua case was brought. First, the ICJ is indispensable. Second, it is powerful. And third, despite this, its position is precarious. The court has never been more indispensable than it is today. States obviously think so. Their resort to it continues to grow with every passing year. Just look at its current docket. There are more than 25 pending cases. When diplomatic negotiations fail, where else can states go, especially smaller states confronting larger and more powerful neighbors, to find a level playing field for resolving disputes peacefully, honorably, and according to international law? Where else could Nicaragua have taken its dispute with the United States and had any chance of obtaining justice? Where else could the General Assembly have obtained a legal opinion from the world's highest judicial authority on the lawfulness of the United Kingdom's separation of the Chagos Archipelago from Mauritius, or on the legality of Israel's prolonged occupation, settlement, and annexation of Palestinian territory? In the former case, leading to successful bilateral negotiations and an agreement on Mauritian sovereignty, and in the latter, to recognition of the state of Palestine by even more states, and to a high-level peace conference on the two-state solution to be co-chaired by France and Saudi Arabia to search for a peaceful settlement in accordance with international law. The ICJ's indispensability is magnified at a time like the present, when the rules-based order is under what may be its greatest challenge since the Second World War. Today, powerful states in North America, Europe, and Asia, as well as the Middle East, question the universality of fundamental rules that have always been accepted as applying to all states, even challenging peremptory norms enshrined in the UN Charter and the Geneva Conventions. The Security Council is unfortunately of less help than it could be, due to the veto power of some of these same powerful states. In the circumstances, it is the court alone that can be depended on to stand up and stand tall for the application of international law to all states, regardless of size or strength, and in this way, defend, protect, and extend the rule of law. The court is not only the principal guardian of the international legal order. For those of us who truly believe in international law, the court is nothing less than the defender of our faith. And the court is powerful. It decides cases and resolves disputes, real disputes over complex issues vital to states, on the legality of the use of force, on self-defense, land and maritime boundaries, sovereignty over islands and disputed territory, environmental harm, control over and use of watercourses, human rights violations, racial, ethnic, and gender discrimination, genocide, torture, protection of diplomats and diplomatic premises, financing of terrorism, climate change, and the list goes on and on. When it has jurisdiction, there is nothing to prevent the court from deciding these cases and issuing legally binding judgments. No judge, not even from a P5 state, can veto a decision. In fact, as we've seen over the last 7 years, P5 states are not even assured a seat on the court. It is one judge, one vote, and the majority rules. And that is as it should be. What is not sufficiently appreciated is that states actually comply with the court's judgments in the overwhelming majority of cases, even when they're dissatisfied. These judgments not only resolve particular disputes peacefully, they clarify and develop the law by determining the circumstances in which it applies, by educating the international community on what rules they're expected to follow, and by setting precedents that guide states in their future conduct. However, notwithstanding its indispensability and its power, the court's position is inherently precarious. Its jurisdiction over states is far from universal, and it has no enforcement arm to ensure compliance with its orders or judgments. In contrast to national courts, which can count on an executive branch to bring recalcitrant parties into compliance if they ignore its rulings, the only recourse for a state seeking to enforce an ICJ judgment is the Security Council, which has not been effective in this role. Nicaragua tried in 1986, but the Council did nothing. It was handcuffed by the US veto. Fortunately, the court's judgment had a greater impact on the US Congress, which voted to terminate funding for the unlawful US activities, and substantial compliance was ultimately achieved in that manner. More recently, the Security Council has issued statements calling for compliance with the court's provisional measures orders in Guyana v. Venezuela, a case in which I represent Guyana. This is helpful, but it's not enforcement. Outright defiance of the court is not common, but it happens. And when it does, it can be infectious. If some state actors refuse to comply with the court's rulings and they get away with it, there is a real danger that others will be emboldened to follow suit. What would happen to the court and to international law if a significant number of respondent states simply refused to appear or abandoned the proceedings before the merits of the case could be decided? The stature of the court, its influence, and our confidence in its ability to successfully resolve disputes would be significantly impaired. If the rule of law is itself on shaky ground in today's world, then the judicial institution that sits atop this unstable structure inevitably finds its situation precarious through no fault of its own. These are some of the factors that make the court unique and that require the lawyers who practice before it to ask themselves whether the uniqueness of the court affects how we litigate or how we should litigate when we're before it. My own answer to this question is an emphatic yes. What I've learned since the Nicaragua case is that litigation practice before the court is as unique as the court itself. And I'll tell you why I think this is so. It's often said that lawyers are officers of the court. What this means to me is that we have a duty to be respectful to the court, to observe its procedures and comply with its rulings, to be honest and ethical in our pleadings, and to refrain from any actions or statements that might bring the court into disrepute. I think these are obligations we owe to every court in which we litigate. But it's not enough when we practice before the ICJ. To understand what else is expected of us, it's helpful to ask ourselves why we have chosen to, why we aspire to, or why we find it so fulfilling to practice before the ICJ in the first place? I think the answer may resonate with most of us in this room. We have made a decision to dedicate our professional lives, and for many of us, a large part of our personal lives as well, to the field of international law, whether as a practicing litigator, a professor, a researcher, a government official, or for a chosen few, a judge on the World Court. We have made this decision because we believe in international law. We believe that a rules-based international order is essential to peace and security, to justice and human rights, to cooperation among nations, and to the full flowering of our common humanity. And we believe that by helping to build, spread, and strengthen the rule of law, in whatever small ways we can as individuals, we contribute to these noble ends and give meaning and purpose and value to our lives. Those of us who have become international litigators pursue these objectives through our practice before the court. To be sure, our duty is to represent our sovereign clients to the best of our abilities and to help them achieve their legitimate objectives in seeking recourse to the court if they're applicants, or in defending their rights and interests if they're respondents. To this extent, what we do in the ICJ is not dissimilar to what lawyers do when they represent individuals or corporate clients in their domestic courts. That's what I did during my first 8 years as a lawyer, before I began to represent sovereign states in international litigation. I was a trial lawyer with a national practice, litigating cases across the United States. My goal was to do everything I could to win the case for my client, operating within the rules, of course. What did not concern me then was the impact my arguments, if successful, would have on the court or on the legal system. I never thought about whether I was asking the court to do more than it should, or to make a decision that might expose it to criticism or even ridicule. It didn't occur to me or affect my actions that a poorly reasoned judgment in favor of my client might undermine respect for the court or the legal system it represents. There are hundreds of judgments issued by U.S. courts, federal and state, every day. It's very rare, if ever, that any one of them, especially at the trial court level, impacts public faith in the efficacy of the rule of law. The ICJ is very different in this regard. The rules-based international order is tenuous in the best of times, and the court's judgments and the way they are perceived can strengthen its foundation by making a new contribution to the peaceful and just resolution of disputes. Conversely, an unwise or poorly perceived judgment can diminish states' respect for the court and the rule of law generally. I think scholars and practitioners, and even many judges, would agree that following its judgments in the Southwest Africa cases in 1966, it took the court 20 years to overcome the damage it did to its reputation and to the faith of many emerging states, which for a time tended to perceive the ICJ as an artifice for preserving the dominance of the more economically developed and powerful Western states, rather than a judicial body dedicated to ensuring equal justice for all states. My point here is that as practitioners before the ICJ, we have a dual responsibility. As in domestic courts, we have a duty to represent our clients to the best of our abilities. But as international lawyers, we also have a duty to the court to help it as best we can, to reach a decision that is consistent with law and justice and enhances rather than detracts from its legitimacy, its credibility, and its influence. Unlike litigating before a domestic court, we fail in this duty when we attempt to push the court too far in an effort to obtain maximalist benefits for our clients, or when we stretch our presentations on the facts of the law beyond their reasonable limits for the same purpose. There is thus an inevitable tension between serving the immediate needs of the client and doing service to the larger institutional interests of the court and the rules-based order that it represents, interests that our clients may very well share. This duality of roles arises, for example, when we advise our clients whether they should go to the court in the first place. Is this a case that asks the court to go too far, jeopardizing its legitimacy and credibility in the eyes of the international community? In 1984, there were some, especially in Washington, who thought that Nicaragua v. United States was such a case. I attended the annual meeting of the American Society of International Law for the first time that year. It was held very shortly after the case was filed. Since no one knew me, I was able to remain below the radar and take in everything I could. The case was uniformly denounced by leading American academics and State Department lawyers. I remember one of the most prestigious, who taught at Yale Law School, telling the audience that international courts should never question the legality of a great power's conduct when it acts in what it considers its national security interests. I recall his words very carefully. What is called for in the Nicaragua case, he said, is judicial pusillanimity. Uttering those words, even 4 decades later, still leaves a sour taste in my mouth. Thankfully, far from pusillanimous, the court was, if anything, courageous in the Nicaragua case, and I think history has more than justified the court's willingness to hold the United States accountable under the same fundamental rules of international law against the use of force that apply to every other state. I've been counsel in other cases that required the court to consider extending itself beyond what many scholars thought to be its comfort zone. Georgia v. Russia was one of them. Russia's invasion of its territory, this case was Georgia's response to Russia's invasion of its territory in 2008. There was no jurisdictional basis for suing Russia on grounds of illegal use of force. But Russia had accepted the court's jurisdiction for suits under the 1965 Convention on the Elimination of All Forms of Racial Discrimination. As Georgia's counsel, we had to consider whether invoking that convention was an appropriate vehicle for establishing Russia's consent to the court's jurisdiction or a pretext to pursue claims that Russia had never consented to litigate. This was an important matter because to a great extent the court's legitimacy depends on its scrupulous adherence to the doctrine that sovereign states may not be subjected to its jurisdiction without their consent. Our legal team agreed to accept the case only after satisfying ourselves that one of the main Russian objectives in invading South Ossetia, the Georgian province that bordered southern Russia, was to expel ethnic Georgians from this mixed ethnic province and leave it in the exclusive control of the Russia-sympathizing Ossetian people as a prelude to setting it up as a separate puppet state aligned with Russia. There was abundant evidence from credible United Nations and other sources of the massive ethnic cleansing of Georgians and their forced exodus south to interior regions of Georgia. This was enough to convince us that the convention was violated and that it was a proper instrument to establish Russia's consent to the court's jurisdiction for a claim of ethnic cleansing, but not for the illegal use of force. The Genocide Convention is another vehicle for establishing consent to the court's jurisdiction that is capable of abuse. There is as yet no convention on crimes against humanity, and therefore no clause consenting to ICJ jurisdiction in regard to these horrendous crimes. For this reason, there has been a temptation to characterize crimes against humanity as genocide to shoehorn them into Article 9 of the Genocide Convention, which vests jurisdiction in the court. In my opinion, it does not serve the interests of the court for counsel to urge it to accept such cases and thereby circumvent the consent requirement. There are, of course, real cases of genocide where both parties have accepted the court's jurisdiction under Article 9. Our legal team for the Gambia, for example, thoroughly reviewed all the voluminous evidence, much of it compiled by United Nations fact-finding missions, before concluding that what occurred in Myanmar was indeed a genocide of the Rohingya Muslim population. And we agreed on that basis to bring a case against Myanmar, since both states were parties to the convention and neither state had made a reservation to Article 9. The tension between representing a client and helping the court can also arise when you're defending a state, especially when its defenses or the defenses it wants you to prevent do not seem credible enough to you to warrant their acceptance by the court. For me, the proper response is just say no and decline the representation or offer to resign. Sometimes it's difficult to do so, like when the client is one you've represented for a long time. How can you walk away from a loyal client when it needs you most? Well, my most uncomfortable experience in the court was when I decided I could not abandon a long-standing client. This was in the Certain Activities case in 2010, when the client was Nicaragua, which had been sued by Costa Rica for violating its sovereignty by digging a canal across disputed territory. There were no good arguments to prevent provisional measures from being ordered, and James Crawford was counsel for the other side. For a litigator like me, it's difficult to imagine a worse predicament. Inevitably, the hearing went as you might have expected, and Nicaragua was ordered to stay out of the disputed territory by a unanimous court. There are times, very painful times, when you have to sever your relationship with the client altogether. I was very fortunate to represent Nicaragua in numerous cases. I'll always be grateful for the opportunities it gave me, and I trust I reciprocated with my contributions to some important victories that were achieved. The country will always be very dear to me. But several years ago, when the government turned dictatorial and began arresting every opposition figure or critic, including some of my oldest and closest friends who had served the country honorably, only to be imprisoned and tortured, I could no longer allow myself to be associated with it, and I submitted my resignation. It was not easy for me, but I have never doubted it was the right thing to do. You might have seen the Hollywood film Hook, which tells the story of Peter Pan as a grown-up, after he has become a prospered corporate lawyer with a prominent Wall Street firm. There is a scene where Peter is the main speaker at a dinner, and he tells the audience in jest of a news report that scientists have begun to use lawyers instead of rats in their laboratory experiments. This is because, Peter explains, one, there are more of them. Two, the lab technicians don't grow as fond of them. And three, there are some things that rats just won't do. This was intended to be funny, of course, but it caused me to ask myself seriously, what is it that I, as a lawyer, just won't do? This helps me understand what my principles truly are, not just the ones I espouse, but the ones I actually live by, including the principles which guide my practice as a litigator before the ICJ. I'm frequently called upon by clients and teammates to argue the facts. I very much enjoy doing so for two reasons. First, it allows me to draw upon the experience and skills I developed as a trial lawyer, where building a case based on the evidence and finding and exposing flaws in the other side's evidence are of paramount importance. And second, I think presenting and explaining the facts and how they should affect the outcome of the case is one way to be most helpful to the court, particularly because it's a court of first as well as last instance, which makes fact-finding an essential part of its task. Of course, in most cases, I argue about the law as well. But the judges are already experts on the law. They don't always need it explained to them by counsel, except where it's unclear or there's uncertainty over how it should be applied in the circumstances of your case. In contrast, the facts are completely different every time around, and the judges have to learn them anew each time. In many cases, they're abundant, complex, or highly technical. The court needs to apprehend and absorb them and determine the credibility and weight to be given to them. Many times, this is a daunting task. And it can be even more challenging for judges who have never litigated a case as an advocate or presided over a national court vested with the power to adduce evidence, as in civil law countries, or to evaluate it, as in common law jurisdictions. It's no secret that a number of scholars and some states have expressed doubts about the court's competence to find the facts. Based on my experience on the ground, which is to say in the court, actually litigating cases, I strongly disagree with the court's critics. From my perspective, whatever the challenges, and some of them are real, the court can be counted upon to get the facts right. Of all my cases, I cannot think of one in which the court failed to do so. But this doesn't mean that the court has no need of help from counsel when it comes to the facts. To the contrary, this is one of the most important roles we play. Among the most beneficial aspects of oral hearings, in my opinion, is that they give counsel the opportunity to help the court make sense of the facts, especially when they seem confusing or contradictory. I'll give you an example. In the pulp mills case, Argentina and Uruguay included experts in their delegations who gave directly contrary evidence about the environmental impacts of Uruguay's pulp mill. In the middle of Uruguay's first round, Judge Benuna asked a prescient question. How is the court to know which experts to believe when they're paid by the parties and can't be considered truly independent? We saw this as a call for assistance from counsel in assessing the evidence, in this case, expert evidence on highly technical issues. My teammates and I went back to our hotel, tore up the speech I had already prepared for the following day, and we spent all night drafting a new one, addressed precisely to this issue, which we assumed was of concern to more than one judge. In our new speech, we agreed that experts paid by the parties could not be regarded as independent. But this did not mean the court should disregard their evidence. It should still evaluate it and determine how much credibility and weight to give it. However, our main argument in the new speech was that there was compelling evidence in the record that was provided by truly independent experts. The environmental scientists retained by the International Finance Corporation, which funded the pulp mill, on the basis of their conclusions that there were no significant risks that the project would cause environmental harm. And we urged the court to rely on that evidence. In its judgment, whether or not our attempt to assist the court had any influence, something it's impossible for us to know, the court did rely on the IFC expert studies, and it upheld Uruguay's right to operate the pulp mill. In presenting the facts to the court, a litigator's credibility is of paramount importance. Credibility is composed of at least two vital components. One, of course, is honesty. But honesty alone is not enough. It must be accompanied by accuracy, scrupulous, impeccable, and complete accuracy. You can honestly lead the court astray. If you think you know the facts, but you haven't studied them thoroughly enough to get them right. You would be surprised by the number of eminent counsel who are experts on the law, but simply don't get the facts right or fully right in their pleadings to the court. Some of what I consider my most effective second round or rebuttal arguments have centered around exposing these factual errors. I'm therefore obsessive in preparing my own pleadings to ensure that I'm not vulnerable to the same kind of counterattack. First, although I sometimes have other lawyers assisting me, I personally review all the evidence myself very carefully. It's my credibility that's on the line, and I cannot entrust this to others. Second, it is my duty to the court to be accurate in presenting and describing the evidence, and I am the one to be held accountable for not getting it perfectly right. If I don't, the court will remember that the next time I appear before it. Third, whenever possible, I like to show the evidence to the court rather than simply tell them about it. Seeing is believing, and when the judges see the evidence for themselves, they don't have to rely entirely on counsel's description of it, which they might question because, after all, as advocates, we're not impartial. An effective way to display the evidence is with PowerPoint slides and by guiding the judges through them. Of course, in complex cases, you can't put all the evidence on slides. There's not enough time, and too many slides become tiresome. You have to limit the projections to the most important evidence and use your best judgment of how much of it to display, and then make the displays as easy to read and understand as possible, because the judges will have only a few seconds to appreciate them. In the advisory opinions on the legality of Israel's occupation of Palestinian territory, I displayed numerous slides with incriminating statements by senior Israeli officials, including the Prime Minister, regarding the intended permanence of the occupation and the de facto annexation of extensive parts of the West Bank. I believe that when the judges saw these statements and read them for themselves, it gave them more credibility and more punch, and made a stronger impact than if I had simply read them aloud. Another important way to help the court at the oral hearings, and your client at the same time, is to craft and deliver your pleading in a way that holds the court's attention from beginning to end. Although this is an obvious goal of any oral pleading, achieving it can be quite challenging, especially for speeches of 30 minutes or more. If you lose the court's attention, or the attention of several judges, you're not only failing to help them, you're wasting your time and theirs. If you lose their attention even for a few moments, you might have difficulty recapturing it. This is why every word of your speech is important and must be crafted carefully and with a view to making your points as clearly, as persuasively, as interestingly, and even when appropriate, as entertainingly as possible. This is how I try to do it. The first rule is clarity. The second rule is clarity, and so is the third. You need to be even clearer in your oral pleading than in your written one, although clarity of expression is critical to both. In your written pleading, if there's a difficult paragraph, the reader can stop and reread it several times if necessary. But that's not possible when you're pleading orally. You have to be clear enough so that the judges can stay with you line by line, because they can't go back and listen again in real time to what you just said. If you confuse them, you will leave them trying to figure out what you just said instead of listening to what you have gone on to say, which could be the most important part of your speech. You have to remember that you will likely be one of several speakers grouped together in 2 3-hour sessions, consuming the entire day, sandwiched around the lunch break. Have you ever sat through a full day of speeches as a listener, day after day? I've done it several times during advisory proceedings. After pleading for my client on the first day of hearings, I attended the sessions over the next several days to listen to the pleadings of other states. All I can say is that as interested as I was in the subject matter, it was difficult to keep my mind from wandering, or even at times, to tell you the truth, especially late in the day, to keep my eyes open. I learned to appreciate the judges even more for steadily maintaining their concentration until 6 p.m. Here's how to help them stay with you and stay awake. First, cut out from your speech anything that is unnecessary to say. This is difficult because when we draft a paragraph or even a phrase, we're convinced it's important and needs to be said. But that's not always right. Put the speech down for a few days. When you come back to it, you'll find that you're not as wedded to the text. And you'll also find, sometimes to your surprise, that there are parts of it that can be deleted without sacrificing substance. Be ruthless with yourself. Too much verbiage is deadly for a speech. Make it as crisp and efficient as possible. Second, don't read the speech in a monotone. That's as good as distributing sleeping pills to your audience. Vary your pace. Slow down when you're making your most important points to better allow the judges to hear and digest them. Vary your volume. When you come to something you want to emphasize, speak louder or speak softer. Either will do. Or take a strategic pause and a sip of water. It allows the point you just made enough time to sink in, and it can give the judges a brief moment to catch their breath after a high-intensity section of your speech. There's an illustration. Third, make eye contact with the judges, but not too much. This establishes a connection and draws your audience to you and into your speech. But avoid giving any judge the impression that you're focusing on him or her, or watching for signs of approval, because this can be very off-putting. Oral hearings are where the judges listen to and watch you, not you them. Fourth, when you can, use humor as a tactic to expose the contradictions, illogic, or lack of foundation in the other party's case. If employed properly, humor can be a highly effective rhetorical tool. There are few things more uplifting to an advocate than getting the court to laugh at your opponent's argument. But bear in mind, there are even fewer things more disheartening than making a joke that falls flat, or one that makes the judges cringe because of its offensiveness to the other side. I'm talking here about polite or playful humor, not meanness. I learned how to use humor by studying one of the best, not only at humor, but at advocacy in general, James Crawford. I learned far more than that from him and from other truly outstanding advocates like Philippe Sands, Alain Pellet, and Laurence Poisson de Chazorn, who has very deservedly received the high honor of being chosen to give this year's general course. What all of them have always exhibited was nothing less than what I would describe as a reverence for the court. To be sure, the court is composed of individual judges who, as human beings, are not and would not claim to be infallible. But once they put on those black robes and the bailiff announces in his distinguished voice, "La Cour," and they walk into the great hall of justice in single file to take their seats behind the bench, they are transformed into something much larger than themselves. The world's highest and foremost judicial authority, and its main instrument for the peaceful settlement of disputes between states according to international law. In that collective capacity, they deserve our reverence. I cannot end this lecture without recalling for you one attempt at humor that I believe landed well and that I have good reason to remember. It was in the second round of the pulp mills case, and Uruguay, as the respondent state, got to speak last. We were attempting to rebut Argentina's scientific evidence by making fun of it, because we thought it was very weak and ripe for ridicule. Responding to Alain Pele, I said, Argentina's case is so desperate that they even drafted Professor Pele, one of the greatest legal minds of our time, not to talk about law, but to hyperventilate about nonylphenols, of all things. That's like hiring Picasso and telling him to go paint your kitchen. The line drew smiles all across the bench, but the one who got the most enjoyment out of it was Alain himself. 3 months ago, when both he and I were here to plead for Palestine in the advisory proceedings on Israel's prevention of humanitarian aid to Gaza, one of our teammates asked Alain, what was the best compliment he ever received? Maybe because I was there. He said, well, one of them was in the pulp mills case when Paul called me Picasso. Over the years, Alain and I have appeared in quite a few cases together, sometimes as rivals, but more often as teammates. I admire him greatly. To me, he really is the Picasso of international law. There are 3 things that both of us share with Picasso. We're white, male, and from the West. This is true of too many practitioners before the court. It's a vestigial reminder of a less enlightened historical era, when not only the advocates, but also the judges were the same color and gender. Unfortunately, change has come more slowly to the bar than to the bench. This is because states like to play it safe by retaining counsel who are the most experienced. However, unintentionally, this perpetuates the inequalities of the past. I feel we have a duty as officers of the court to correct this injustice by helping make the bar as diverse as the court. I know the judges would like to see this happen, and we can help them. We can use our standing with our clients to persuade them that they will be better served, and they will be, by teams of highly talented advocates who reflect the world as it is, in all its beautiful diversity of gender, color, race, and nationality. The talent certainly exists across all these categories. You can see it on display at the oral hearings and advisory proceedings. Because of the number of states participating, there are opportunities for advocates other than the usual suspects. It's our responsibility to the court, to our clients, and to the next generation of international lawyers to open the doors of ICJ practice to them. Even if it means that people like me must step aside from time to make room for them. I will leave you with this. Earlier this year, Uruguay, which I have been representing in international disputes for the past 20 years, lost its greatest statesman, former President José Mujica, an extremely wise and decent man with exemplary human values. As president, he lived in the same humble bungalow and drove the same beat-up Volkswagen Beetle as he did before he took office. In his final interview before his death, he said, "The problem is that the world is run by old people who forget what they were like when they were young." When I was young, I helped Nicaragua bring its case to the International Court of Justice. I had to leave my law firm to do it because they refused to let me take the case. My principles, my belief in international law, and my reverence for the court have not changed. 40 years later, I left another law firm because they would not allow me to represent Palestine in the ICJ. I was 75 at the time, now I'm 77. And some of you may consider me an old man. But I am determined not to forget, and I will not forget, what I was like when I was young. And I hope all of you will be able to say the same thing when you look back on your own long life and illustrious careers. Thank you very much for being such a courteous and attentive audience. And thank you again to the Hague Academy for inviting me to speak here today.